Hi, on behalf of LJ Hooker, we would like to thank you for taking the time to watch this video. As you may or may not know, there have been quite a few changes to the Residential Tenancy Agreement. These changes will affect you directly, and as your Property Management Office, we are required to detail all the rights and obligations under the amended agreement. So get comfortable and follow along with your hard copy for the next few minutes.
Right to occupy the premises. The tenant has the right to exclusive occupation and quiet enjoyment of the residential premises during the tenancy. The residential premises include the additional items, but do not include the exclusions noted under residential premises in Part A. Copy of agreement. The lessor or the property manager must give the tenant a copy of this agreement when this agreement is signed by the tenant, and a copy of this agreement signed by both the lessor or the property manager and the tenant within 14 days after it has been signed and delivered by the tenant. The tenant must pay rent on time, or the lessor may issue a notice of termination. And if the rent is still not paid in full, the lessor may take action through the court to evict the tenant. The tenant must not withhold rent because the tenant is of the view that the lessor is in breach of the agreement. The lessor or property manager must not require the tenant to pay more than 2 weeks' rent in advance, or require the tenant to pay rent by post-dated cheque, or use rent paid by the tenant for the purpose of any amount payable by the tenant other than the rent, or require the tenant to pay any monetary amount other than the rent, security bond and pet bond. The lessor or property manager must give a rent receipt to the tenant within 3 days of the rent being paid, unless the rent is paid into an authorised bank or credit union account nominated by the lessor. A tenancy agreement cannot contain a provision for a penalty, damages or extra payment if the tenant fails to keep to the agreement or breaches any law. If an agreement allows a reduced rent or a rebate, refund or other benefit, if the tenant does not breach the agreement, the tenant is entitled to the reduction, rebate, refund or other benefit in any event. Warning: it is an offence for a tenant to fail or refuse to pay any rent due under a residential tenancy agreement with the intention that the amount of such rent be recovered by the lessor from the tenant's security bond. Payments of council rates, land tax, water and other charges. The lessor must pay all rates, taxes or charges imposed in respect of the premises under the Local Government Act 1995, the Land Tax Act 2002, or any written law under which a rate, tax or charge is imposed for water supply or sewerage services under the Water Agencies Powers Act 1984, other than a charge for water consumed. The lessor is responsible for any contribution levied under the Strata Titles Act 1985 and any contribution levied on a proprietor under the Strata Titles Act 1985. Public Utility Services. Public utility services has the meaning given in the Land Administration Act 1997 and refers to services such as gas, electricity and water. If the premises are not separately metered to measure the tenant's consumption of a public utility service at the premises, the tenant is expected to pay for his or her consumption of the public utility service. The lessor and tenant must agree in writing to an alternative method of calculating the charge to be paid by the tenant for the consumption of that public utility service. The tenant must not be required to pay a charge in relation to a public utility service provided to the premises, unless the charge is calculated by reference to the tenant's actual consumption of the public utility service at the premises, and the tenant is given written notice of the charge. If the premises are separately metered, the notice of the charge must specify the relevant meter reading or readings, and the charge per metered unit, and the amount of GST payable in respect of the provision of the public utility service to the residential premises. If the premises are not separately metered, the notice of the charge must specify the calculation as per the agreed method and the amount of GST payable in respect of the provision of the public utility service to the residential premises. Possession of the premises. The lessor must Give the tenant vacant possession of the premises on the day on which the tenant is entitled to enter into occupation of the premises under the agreement, and take all reasonable steps to ensure that, at the time of signing his agreement, there is no legal reason why the tenant cannot occupy the premises as a residence for the term of this agreement. Tenant's rights to quiet enjoyment. The tenant is entitled to quiet enjoyment of the premises without interruption by the leaseor or any person claiming by, through or under the leaseor or having superior title to that of the leaseor. The leaseor or the property manager will not interfere with or cause or permit any interference with the reasonable peace, comfort or privacy of the tenant in the use of the premises. The leaseor or the property manager must also take all reasonable steps to ensure that the leaseor's other neighbouring tenants do not interfere with the reasonable peace, comfort or privacy of the tenant in the use of the premises. Use of the premises by tenant. The tenant must use the premises as a place of residence and not use or allow the premises to be used for any illegal purpose, and not cause or permit a nuisance, and not intentionally or negligently cause or permit damage to the residential premises, and advise the leaseor or property manager as soon as practicable if any damage occurs, and keep the premises in a reasonable state of cleanliness, and not cause or allow to be caused injury to the leaseor, property manager, or any person lawfully on adjacent premises, and not allow anyone who is lawfully at the premises to breach the terms of this agreement. The tenant is responsible for the conduct or omission of any person lawfully on the premises that results in a breach of the agreement. Leaseor's general obligations for residential premises. In this clause, premises includes fixtures and chattels provided with the premises but does not include any fixture or chattel disclosed by the leaseor to the tenant as not functioning before the agreement was entered into, or any other fixture or chattel that the tenant could not reasonably have expected to be functioning at the time the agreement was entered into. The leaseor must provide vacant possession of the premises and in a reasonable state of cleanliness and repair, and maintain and repair the premises in a timely manner, and comply with all laws affecting the premises, including building, health and safety laws. Urgent repairs. Urgent repairs are defined by the Residential Tenancies Act 1987 and fall into two categories: repairs that are necessary for the supply or restoration of an essential service and other urgent repairs. Essential services are listed in the Residential Tenancies Regulations 1989 as electricity, gas, a functioning refrigerator, if one is provided with the premises, wastewater management treatment, and water, including the supply of hot water. Arrangements for repairs that are necessary to supply or restore an essential service must be made with a suitable repairer within 24 hours. Other urgent repairs are those that are not necessary for the supply or restoration of an essential service, but may nevertheless cause damage to the premises, injure a person, or cause undue hardship or inconvenience to the tenant. Arrangements for these repairs must be made within 48 hours. In every tenancy, if the need for urgent repair arises other than as a result of a breach of the agreement by the tenant is to notify the leaseor or the property manager of the need for urgent repairs as soon as practicable. And the leaseor is to ensure that the repairs are carried out by a suitable repairer as soon as practicable after that notification. And if, within 24 hours in the case of repairs to essential services, or 48 hours in the case of other urgent repairs, the leaseor or property manager cannot be contacted, or having notified the leaseor or property manager of the need for the repairs, the leaseor fails to ensure that the repairs will be carried out by a suitable repairer as soon as practicable after that notification, the tenant may arrange for the repairs to be carried out by a suitable repairer to the minimum extent necessary to effect those repairs. And if a tenant arranges for repairs to be carried out under clause 23.3, the leaseor must, as soon as practicable after the repairs are carried out, reimburse the tenant for any reasonable expense incurred by the tenant in arranging for those repairs to be carried out and paying for those repairs. Lessor's access to the premises. The lessor, property manager, or person acting on behalf of the lessor can only enter the premises in the following circumstances. In any case of emergency, to conduct up to 4 routine inspections in a 12-month period after giving the tenant at least 7 days, but not more than and 14 days written notice. Where the agreement allows the rent to be collected at the premises where rent is payable, not more frequently than once every week. To inspect and secure the premises if there are reasonable grounds to believe that the premises have been abandoned and the tenant has not responded to a notice from the lessor. Carrying out or inspecting necessary repairs to or maintenance of the premises at any reasonable time after giving the tenant not less than 72 hours notice in writing before the proposed entry, showing the premises to prospective tenants at any reasonable time and on a reasonable number of occasions during the period of 21 days preceding the termination of the agreement after giving the tenant reasonable notice in writing. Showing the premises to prospective purchasers at any reasonable time and on a reasonable number of occasions after giving the tenant reasonable notice in writing, or if the tenant agrees at or immediately before the time of entry. There are directions within the Residential Tenancies Act 1987 which guide tenants, lessors and property managers on appropriate behaviour in relation to gaining or granting access to the premises. The following summary may assist. Reasonable time. Reasonable time means between 8 a.m. and 6 p.m. on a weekday, or between 9 a.m. and 5 p.m. on a Saturday, or at any other time agreed between the lessor and each tenant. Requirement to negotiate a day and time for a proposed entry by the lessor. The lessor or property manager must make a reasonable attempt to negotiate a day and time that does not unduly inconvenience the tenant. Requirement to give tenant notice of proposed entry. Where a lessor or property manager gives a tenant notice of an intention to enter the premises on a particular day, the notice must specify the day and whether it will be before or after 12 p.m. Tenant entitled to be present. The tenant is entitled to be on the premises during the entry by the lessor, the property manager, or any other agent acting on behalf of the lessor. Entry must be reasonable and no longer than necessary. The lessor or property manager exercising a right of entry must do so in a reasonable manner and must not, without the tenant's consent, stay or permit others to stay on the premises longer than is necessary to achieve the purpose of the entry. Lessor's obligation to compensate tenant if damage to tenant's goods. If the lessor or property manager, or any person occupying the lessor or property manager, causes damage to the tenant's goods when exercising a right of entry, the lessor is obliged to compensate the tenant. Alterations and additions to the premises. If the tenancy agreement allows the tenant to affix a fixture or make a renovation, alteration or addition to the premises, then the tenant must obtain permission from the lessor prior to affixing any fixture or making any renovation, alteration or addition to the premises. The tenant must obtain permission from the lessor to remove any fixture attached by the tenant and make good any damage, and notify the lessor of any damage caused by removing any fixture and, at the option of the lessor, repair the damage or compensate the lessor for any reasonable expenses incurred by the lessor in repairing the damage. And the lessor must not unreasonably refuse permission for the installation of a fixture or an alteration, addition or renovation by the tenant. If the lessor wants to make an alteration or addition or affix a fixture to the premises, then the lessor must obtain the tenant's permission prior to affixing any fixture or making any renovation, alteration or addition to the premises. And the tenant must not unreasonably refuse permission for the lessor to affix any fixture or make any renovation, alteration or addition to the premises. Locks and security devices. The prescribed means of securing the premises are defined in the Residential Tenancies Regulations 1989. In every tenancy, the lessor must provide and maintain such means to ensure the premises are reasonably secure as prescribed in the regulations. and any lock or security device at the premises must not be altered, removed or added by a lessor or tenant without the consent of the other. And the lessor or the tenant must not unreasonably withhold that consent. Transfer of tenancy or subletting by tenant. If the tenancy agreement allows the tenant to assign his or her interest or sublet the premises with the lessor's consent, the tenant cannot assign his or her interest or sublet the premises without the written consent of the lessor, and the lessor must not unreasonably withhold such consent, and the lessor must not make any charge for giving such consent other than the lessor's reasonable incidental expenses. Contracting out. It is an offence to contract out any provision of the Residential Tenancies Act 1987. Ending the Residential Tenancy Agreement. This Residential Tenancy Agreement can only be terminated in certain circumstances. The tenant agrees, when this agreement ends, to give vacant possession of the premises to the lessor. Before giving vacant possession to the lessor, the tenant must remove all the tenant's goods from the residential premises and leave the residential premises as nearly as possible in the same condition, fair wear and tear expected as at the commencement of the tenancy, and return to the lessor all keys and other opening devices or similar devices provided by the lessor. The tenant may be liable for losses incurred by the lessor if the above requirements are not met. Ending in a fixed term agreement. If this agreement is a fixed term agreement, it may be ended by agreement in writing between the lessor and the tenant, or if either the lessor or tenant does not want to renew the agreement, by giving written notice of termination. The notice must be given to the other party at least 30 days prior to the date on which vacant possession of the premises is to be delivered to the lessor. The notice may be given at any time up until the end of the fixed term, but cannot take effect until the term ends. Ending a periodic agreement. If this agreement is a periodic agreement, it may be ended by agreement in writing between the lessor and the tenant, or by either the lessor or the tenant by giving written notice of termination to the other party. The notice may be given at any time. The lessor must give at least 60 days notice, and the tenant must give at least 21 days notice. Other grounds for ending agreement. The Residential Tenancies Act 1987 also authorises the lessor and tenant to end this agreement on other grounds. The grounds for the lessor include sale of the residential premises, breach of this agreement by the tenant, where the agreement is frustrated, example, where the premises are destroyed or become uninhabitable, and hardship. The grounds for the tenant include breach of this agreement by the lessor, where the agreement is frustrated, example, where the premises are destroyed or become uninhabitable, and hardship. For more information, refer to the Residential Tenancies Act 1987 or contact the Department of Commerce on 1300 304054 or visit www.commerce.wa.gov.au/consumer protection. Warning: it is an offence for any person to obtain possession of the residential premises without an order of the Magistrates Court if the tenant does not willingly move out. A termination notice issued by the lessor or property manager is not a court order. The court may order fines and compensation to be paid for such an offence. It is an offence for a tenant to fail to provide the lessor with a forwarding address when vacating the premises. Security bond. The security bond is held by the bond administrator. The lessor agrees that where the lessor or the property manager applies to the bond administrator for the release of the security bond at the end of the tenancy, the lessor or property manager will provide the tenant with evidence to support the amount claimed. The bond administrator can only release the security bond when it receives either a joint application for disposal of security bond form signed by all the parties to the tenancy agreement, or an order of the court. If the parties cannot agree on how the security bond is to be dispersed, either party can apply to the Magistrates Court to have the dispute decided. Warning: It is an offence for a leaseor or property manager to require a tenant to sign a joint application for disposal of security bond form unless the residential tenancy agreement has terminated and the amount of the security bond to be paid to the tenant or leaseor is stipulated on the form. Tenancy databases. A leaseor or property manager can only list a person on a residential tenancy database if the person is a named tenant on the residential tenancy agreement, and the residential tenancy agreement has been terminated, and the person owes the leaseor a debt that is greater than the security bond, or a court has made an order terminating the tenancy agreement. Advice, complaints and disputes. Department of Commerce. The Residential Tenancies Act 1987 allows the Commissioner for Consumer Protection to give advice to parties to a residential tenancy agreement to look into complaints and, wherever possible, help to settle them. The Department of Commerce may be contacted by telephone on 1300 30 4054 or by visiting one of the department's offices. The tenant should generally approach the leaseor or property manager to solve any problem before approaching the Department of Commerce. The department's role is one of mediation and conciliation. It cannot issue orders or make determinations in respect of disputes. If a dispute cannot be resolved. If a dispute arises between the leaseor and the tenant and the dispute cannot be resolved, either party may apply to the Magistrates' Court to have the dispute decided by the court. The court can make a range of orders, including restraining any action in breach of the agreement and requiring a party to the agreement to perform a certain action under the agreement, and order the payment of any amount owing under the agreement, and order the payment of compensation for loss or injury. Important information. Additional terms may be included in this agreement if both the leaseor and tenant agree to the terms and they do not conflict with the Residential Tenancies Act 1987, the Residential Tenancies Regulations 1989, or any other law, and they do not breach the provisions about unfair contract terms in the Fair Trading Act 2010, and they do not conflict with the standard terms of this agreement. Additional terms are not required by the Residential Tenancies Act 1987. However, once the parties sign this agreement, the additional terms are binding upon the parties unless the term is found to be unlawful. Additional terms. Requirements for existence of lease. The parties agree that there will be no binding agreement to lease the premises, and no residential tenancy agreement will have come into existence under the Residential Tenancies Act 1987 or otherwise, unless and until the following prerequisites have been met. By no later than 4 p.m. on the day before lease start date, or such later time as agreed to by the leaseor's property manager. This residential tenancy agreement is signed by the tenant, tenants, and returned by the tenant to the leaseor's property manager at the address appearing in this lease. Any security bond and any pet bond required to be paid by the tenant pursuant to Part A of this residential tenancy agreement on the signing of the residential tenancy agreement are paid to the leaseor's property manager. And any first payment of rent required to be paid by the tenant pursuant to Part A of this residential tenancy agreement on or before the signing of the residential tenancy agreement is paid in accordance with Part A. And the residential tenancy agreement is signed by the leaseor or the property manager, provided that if the tenant has been granted an option to enter the lease and paid an option fee, there shall be no need for the agreement to be signed by the leaseor or property manager in order for a binding agreement to exist, and this prerequisite B shall not apply. The tenant's obligations. Rent. The tenant agrees to pay the rent punctually pursuant to the provisions of Part A on the dates for payment without any deductions or legal or equitable set-offs. The tenant must not fail or refuse to pay any rent due under this lease with the intention that the amount of the rent may be recovered by the leaseor from the security bond. This is an offence against Section 52 of the Act and is subject to the maximum penalty of $5,000.
Refer to Clause 2.3, Renegotiated Fixed Term Lease, Section 31B of the Act. Please refer to page 9 of your residential tenancy agreement to view this clause.
Pets. The tenant must not keep any animal, bird or fish in or about the premises, unless that pet is listed in Part A of this residential tenancy agreement or without the prior written permission of the lessor. The tenant must not keep any restricted breed dogs as defined under the Dog Restricted Breeds Regulations 2002. Doggo Argentine, Argentinian Fighting Dog. Fila Brasileiro, Brazilian Fighting Dog. Japanese Tosa, American Pit Bull Terrier, or any dog of a mixed breed which visibly contains any of these breeds without the prior written consent of the lessor. Pet security bond. If the lessor permits the tenant to keep pets at the premises as specified in Part A, or as agreed in writing after the commencement of the residential tenancy agreement, and if any of those pets are capable of carrying parasites that can affect humans, then the tenant shall deposit with the property manager a pet security bond of the amount referred to in Part A. At the end of the tenancy, that pet bond may be applied to the cost of fumigation of the premises. In this clause, the term pet does not include a guide dog as defined in Section 3, 1 of the Dog Act 1976. Smoking. Unless otherwise agreed to by the lessor in writing, smoking is not permitted inside the residential buildings on the premises. Services. The tenant must notify the electricity and gas utilities, if applicable, of the tenant's occupation of the premises. Telephone. The lessor makes no representations about the availability of telephone lines, internet lines, or any other communication services to the premises. The tenant must make his or her own inquiries regarding the availability, cost, and/or installation of those services. The tenant is allowed to install and/or attach cabling, telephone lines, and/or communications lines to the premises provided no damage is done to the premises in installing, attaching, and/or removing them, and the tenant pays all costs associated with that installation, attachment, and/or removal. If at the end of the residential tenancy, the lessor requests the cabling and/or communications lines to be removed, the tenant must remove them and make good any damage caused by that removal. If any cabling, telephone lines and/or communications lines installed or attached by the tenant are left remaining at the premises or attached to the premises at the end of the tenancy, with the lessor's consent, those items become the property of the lessor. Strata Company. The tenant agrees to comply with all the rules and bylaws governing the use of the premises and the common areas issued by the Strata Company or Strata Council. Tenant to keep premises clean. In accordance with the tenant's obligation to keep the premises in a reasonable state of cleanliness, pursuant to Section 38(1)(a) of the Act, the tenant must keep the premises in a clean and sanitary condition and free from dirt, oils, grease, insects and vermin. The tenant is responsible for the eradication of insect and vermin infestations caused by the tenant's activities or lack of cleanliness. Chattels. Except for matters required to be attended to by the lessor as part of its obligations to maintain the premises in a reasonable state of repair, having regard to its age and character, the tenant agrees to keep the premises, including all floors, floor coverings, skirting boards, walls, ceilings, windows including glass, window treatments, doors including glass if any, light fittings, fixtures and fittings, and chattels included in the tenancy's agreement as set out in any attached inventory, in the same condition as they were in at the commencement of this lease and in accordance with the property condition report, fair wear and tear accepted. Smoke alarms and RCDs. The tenant must take reasonable steps to regularly check and test whether all smoke alarms and residual current devices on the premises are in good working order. If any smoke alarm or residual current device is not at any time in good working order, the tenant must give the lessor immediate notice in writing of that fact. Light globes. The tenant agrees to replace all broken light globes and fluorescent light tubes, and save for matters required to be attended to by the lessor as part of its obligations to maintain the premises in a reasonable state of repair, having regard to its age and character. Ensure all light globes and fluorescent light tubes are kept in good working order. Gardens. The tenant must attend to the garden, lawns, lawn edges, hedges, shrubs and trees so that they are kept in the same condition as at the commencement of this lease as described in the Property Condition Report. To water and fertilise them regularly and adequately, to keep all the grounds clean and tidy and free from rubbish, to keep the flower beds and lawns free of weeds, and not to remove or cut down any plants, trees or shrubs. Swimming pool spa. If the premises includes a swimming pool or spa, the tenant must keep the pool or spa and any associated equipment in a properly treated and clean condition and observe all legal requirements relating to pools and or spas during the period of this lease. The tenant must not drain the pool without the lessor's written consent. Damage and disrepair. The parties' rights and obligations with respect to urgent repairs are set out in Section 43 of the Act and Clauses 22 and 23 of Part B of the Residential Tenancy Agreement. The tenant agrees to report all damage and any state of disrepair to the premises that does not come within the provisions of the Act and this agreement within 3 days of the same occurring. Failure to do so will render the tenant liable for all costs and or losses incurred by the lessor as a result of such failure to report. The tenant must pay for any damages caused by the tenant's breach of the Residential Tenancy Agreement, including, but not limited to, the cost of repairing any damage that is caused by or is attributable to an act or omission by the tenant or anyone who is lawfully at the premises, contrary to Clause 18 and or 19 or Part B. Insurance. The tenant must not do or permit anything to be done or bring onto or keep on the premises anything which may invalidate or prejudice the conditions of any insurance policies relating to the premises or cause to be increased the premiums payable with respect to those policies. Copies of the terms and conditions of the lessor's insurance policies applicable to the premises, if any, are available for viewing by the tenant upon the tenant making a written request. Excess on the insurance. If the lessor elects to claim on the lessor's insurance for any loss or damage that arises or is attributable to an act or omission by the tenant or the tenant's visitors or people associated with the tenant that amounts to a breach of this residential tenancy agreement or would otherwise leave the tenant liable to the lessor for damages, and the lessor is successful in relation to recovering any money for such damage, then the tenant will be liable to the lessor to pay any excess on any such insurance claim. The tenant acknowledges that any damage caused to the premises or any chattels on the premises by a waterbed is not normally covered by insurance. This clause does not limit the liability of the tenant for acts of negligence, other torts or breaches of this residential tenancy agreement, and this clause does not require the lessor to make any claim under any insurance policy held by the lessor. Alterations to the premises. Notwithstanding which election is selected with respect to the right of the tenant to affix and remove fixtures in Part A, the tenant must not place any sign on or paint the premises, use blue tack or any other adhesive material, or drive any nails or screws into or deface any part of the premises. Objectionable behaviour. The tenant must not interfere with or cause or permit interference with the reasonable peace, comfort or privacy of any person who resides in the immediate vicinity of the premises. Waterbeds, aquarium, swimming pool, spa. The tenant must not, without the lessor's prior written permission, install any waterbed, aquarium, swimming pool or spa on the premises. The tenant is liable to the lessor for any costs or losses resulting from any damage caused to the premises, including any of the lessor's chattels, fixtures, fittings and or furniture by the escape of water from any waterbed, aquarium, swimming pool or spa. Laundry. The tenant must not hang or display any laundry or other articles on any balcony or veranda. Indemnify the lessor. The tenant agrees to indemnify the lessor against any loss sustained by the lessor or any sum the lessor might at any time be liable to pay as a result of any damage to the premises or any furniture or chattels belonging to the lessor. Any claim made against the lessor, whether in relation to property damage or personal injury, or any other matter whatsoever arising from any breach of clauses 18 and or 19 of Part B of this residential tenancy agreement. Inspections. Provided that the lessor has complied with clauses 24 to 28 of Part B of this residential tenancy agreement, if the tenant is not present at the time specified in any notice for the inspection provided by the lessor, the tenant agrees that the lessor or the lessor's property manager or their employees may enter the premises. Keys and electronic keys. Subject to the provisions of Section 45 of the Act and Clause 34 of Part B of this residential tenancy agreement, the lessor will supply to the tenant one set of keys that enable access to the premises. Should the tenant require an additional sets of the keys, or the existing set to be recoded through no fault of the lessor, then any cost associated with an additional sets, or recoding will be borne by the tenant and must be paid for by the tenant prior to receiving the additional sets of the keys. Should the tenant lose possession of the keys, then the tenant will be responsible for all costs and expenses associated with replacing the keys or gaining access to the premises. The lessor will replace keys and arrange for access to the premises arising from lost keys only during normal business hours. Default. If the tenant terminates this lease otherwise than in accordance with Clause 37 of Part B of this residential tenancy agreement or pursuant to the provisions of the Act before the end of the tenancy period referred to in Part A, or the tenant otherwise breaches the lease, then the tenant is liable to pay any damages and losses to the lessor that the lessor suffers or will suffer as a result of the tenant's breach. The lessor must endeavour to reasonably mitigate the lessor's damages and losses. End of tenancy. Swimming pool and spa equipment at the end of the tenancy. If at the commencement of the lease, the lessor provided pool chemicals to the tenant, then a comparable quantity of the same chemicals are to be provided by the tenant to the lessor at the end of the lease. The tenant must secure all portable pool cleaning equipment in a locked area on the premises at the end of the tenancy. Movement of chattels. The tenant must return all fixtures, furniture, chattels, household effects and all other items described in either the property condition report or the attached inventory to the original positions described in those documents. Cleaning of carpets. As part of the tenant's obligations under Clause 18.6 of Part B of this residential tenancy agreement, the tenant agrees upon vacation of the premises to have all carpets professionally cleaned at the tenant's expense and to supply to the property manager a receipt as evidence that the carpets have been cleaned. Definitions and interpretation. If any provision of this lease is invalid, unenforceable or illegal, then that provision may be severed and the remainder of this lease will continue to be effective. In this lease, unless otherwise required by the context or subject matter, keys means all keys and electronic keys that permit access to the premises, to common property associated with a strata lot or to car bays associated with the premises. Any reference in this lease to the lessor doing anything shall mean and include it being done by the lessor's property manager. Where either the tenant or the lessor comprise more than one person, the obligations to be performed in this lease are binding upon such two or more persons, jointly and severally. Privacy Act 1988, Collection Notice. Personal information collected by the lessor's property manager through the management of the tenancy including, but not limited to, the property condition report is necessary to manage the tenancy. The personal information collected by the lessor's property manager in this lease in the property condition report and during the period of the management of the tenancy is collected for the purpose of being used in managing the lease of the premises, and the tenant hereby consents to that collection and use. The information collected in this lease, in the property condition report, and during the period of the management of the tenancy may be disclosed by the leasor's property manager to other parties as permitted by the Privacy Act 1988, including to the existing leasor, subsequent leasors, courts of law, other real estate agents, and operators of tenancy reference databases. Further, information already held on tenancy reference databases may be accessed by the leasor's property manager. If the tenant wishes to contact the leasor's property manager or access the personal information the leasor's property manager may hold regarding the tenant may do so by contacting the leasor's property manager at the address described in Part A. The tenant may also request that the information be corrected if it is inaccurate, incomplete, or out of date. If the information referred to in this collection notice is not provided, the leasor's property manager may not be able to manage the tenancy. The leasor's property manager may not be able to manage the tenancy.
That completes the residential tenancy agreement. If you have any questions regarding the video, please ask one of our friendly property managers who would be more than happy to help. Also, if there's any annexures relevant for your property manager will go through these with you. We appreciate your time and understanding during the video. Once again, thank you for choosing LJ Hooker.